Hello, and welcome to the first lecture for Topic 1. And this lecture is about the Bill of Rights and a general overview of the court system. What we're going to be covering in this lecture is we're going to take a look at the process of the ratification of the U.S. Constitution and the role that the Bill of Rights plays in the ratification. And then we're going to look at how the court system in the United States is organized and the different functions that courts play. All right, so let's go ahead and get started. The first thing I want to do is to make sure that we are all on the same page when it comes to the founding documents. They make reference to these in the first chapter, and I just wanted to make sure that we were all on the same page. Okay, so as most of us know, the United States that we know today did not start as an independent state. Rather, it was colonies that were governed by England. And the Declaration of Independence, signed in 1776, has two functions. One is that it officially breaks ties with England and says that it's going to be its own country. It also outlines the sort of general values and beliefs that unite Americans. It's a political manifesto, and it's making an argument for why the United States, based on their values, needs to break ties with England. Now, the breaking ties with England is one thing, but since we were creating our own country, we needed to have a blueprint for governance. And that's what the Articles of Confederation is. That the Articles of Confederation is the first constitution of the United States. As your textbook points out, the Articles of Confederation provides for a really limited federal government with very limited powers. Most of the powers are left to the states. The Articles of Confederation does create a national government, but it only creates a national lawmaking branch, the national legislature. There is no national executive branch, there's no judiciary either. But there were many problems with the Articles of Confederation. Major problems is that the national government didn't have enough power to actually get things done. So in 1786, there was a decision that was made that the Articles of Confederation needed to be revised. And there was a constitutional convention that was held in Philadelphia in 1787. And as your textbook points out, that rather than revising the first Constitution of the United States, an entirely new Constitution was created. It was the second Constitution. And both the Articles of Confederation and the United States Constitution basically tell us about the institutions of governments, what they're going to be, and what their procedures and rules are. And so the Constitution that we have today is obviously the document that was created at the Constitutional Convention in 1787. And then in the commentary for last week, we talked about the Bill of Rights, that being the first 10 amendments to the United States Constitution. And your textbook this week spends time talking about the process of ratifying the United States Constitution and the role that the Bill of Rights played in that. Now, today we take the Bill of Rights as a given. When you think about the Constitution, you almost automatically think about the Bill of Rights. But that was not always the case. As you learn in your textbook this week, that when the Constitution was crafted, it did not include a Bill of Rights. And in a moment, we'll take a look at why those who created the Constitution didn't think that a Bill of Rights was needed. But it became very clear, and they show that in the textbook in a table that shows the ratification process, that it became very clear that after a handful of states ratified the Constitution without a Bill of Rights, it was clear that we weren't going to be able to get enough states. We needed 9 states in order to ratify the Constitution. And so that the big reason why states didn't want to ratify the Constitution is because it did not contain a Bill of Rights. And so an agreement was made that in order to get the Constitution as written ratified, that the Federalists agreed that one of the first acts of Congress would be to craft a Bill of Rights and add it to the Constitution as amendments. So let's take a look at the reasoning that your textbook gives regarding why the Federalists, those who were the ones who crafted the Constitution, didn't feel that a Bill of Rights was needed, but why those who felt a Bill of Rights was needed, what some of their reasons were for that position. So, why didn't the framers, who were primarily Federalists, include a Bill of Rights in the Constitution? Well, for one, those who crafted the Constitution, they did not think that personal freedoms was the focus of the Constitution. The focus of the Constitution, and if you've ever read the 7 Articles of the Constitution, it's really about establishing the institutions of government. And so Article 1 establishes the Congress, Article 2 establishes the presidency, Article 3 establishes the Supreme Court, and so on. And so, as a blueprint for governance, that the thinking is it's really not the purpose of the Constitution to tell us what the individual liberties are. They also felt that a Bill of Rights was not needed, in part because that the government's power was limited to enumerated powers. And so the arguments of the Federalists was that nothing is telling Congress that it can abridge your speech. Nothing is telling in the Constitution tells Congress that they have power to establish a religion. It tells Congress that they can regulate interstate commerce. It tells Congress that it can declare war. But the understanding is that Congress could only do those things. It couldn't engage in activities that were not expressly granted to them. And so they felt that a Bill of Rights was not needed because Congress didn't have that power in the first place. They argued that the Constitution is in itself a Bill of Rights. One, because it limits the powers of Congress to very specific things. But also there are specific liberties that are enumerated in the Constitution, such as the power of that you have the right to you have habeas corpus rights. That is, if you are arrested, you have to be told what you're being charged with and why you're being held. They prohibit bills of attainder and ex post facto laws. And so within the 7 articles of the Constitution are rights. And so that was one of their arguments. And then finally, they argued that writing down and enumerating what the rights of the people are is not only is it unnecessary, but it can also be dangerous and limiting. Because once you sit down and you start saying that Congress can't abridge speech, it can't do this, it can't do that, well, then is that implied that because we didn't say Congress couldn't do it, that they can do it? And so the Federalists just felt that it was unnecessary, but could also be dangerous to include a Bill of Rights. So as you read in your textbook, that many states did not want to ratify the Constitution without a Bill of Rights. And so why did the states refuse to ratify without a Bill of Rights? Well, many of the states felt that the Constitution gave way too much power to the federal government. And if you remember if you've taken an American government class, that at the very end of the enumerated powers of Congress, there is this thing called the necessary and proper clause, or also known as the elastic clause. And it basically says that Congress can do what it needs to do in order to put the aforementioned powers into action. That really freaked out the states. They were sort of like, hey, if we don't say that there are certain things that Congress can't do, they might very well use that elastic clause to do things to really expand their powers. And so they thought a Bill of Rights would put the brakes on federal powers and the abuse of federal powers. Jefferson, as it mentions in your textbook, says that there are just certain rights are just fundamental, they're inalienable. And if you've read the Declaration of Independence, which I hope you have, that's how the Declaration of Independence starts. It says we hold these truths to be self-evident, that all men are created equal, and they are endowed by their creator with certain inalienable rights. The government can't take away from you, and that come from a source outside of government, in this case, the creator. And he said that since that we recognize that there are certain rights that are fundamental, that it's really important that those rights be formally recognized in something like the Bill of Rights. And so for Jefferson, he thought that why not just have a Bill of Rights, since we all agree that there are certain liberties like freedom of speech that should not ever be trampled on by government. There was an argument that there was historical precedent in England, and so you had the Magna Carta in England that establishes certain liberties, as well as a Bill of Rights in England as well as a precedent. And so they said, look, why not include in our Constitution the same bills of rights that have been included in other Constitution and historical documents? And then finally, they said, look, state constitutions have bills of rights and enumerations of rights. Why should the federal government be sort of exempted from that? And as you know from reading your textbook, that the Federalists agreed. They agreed that without the Bill of Rights, the Constitution would not be ratified, and that in order to get that ratification, they compromised and agreed that that was going to be one of the first acts to include the Bill of Rights after the Constitution itself had been ratified. Okay, so we're going to be spending the whole semester talking about the Bill of Rights, or at least most of the amendments and liberties that are enumerated in the Bill of Rights. So here's just a little moment to sort of test yourself. You can test yourself at the beginning of the semester, and then you can test yourself at the end of the semester as well. So the Bill of Rights, we know that they are the first 10 amendments of the United States Constitution. But how well do you know what's contained in the different amendments? I'm going to put the amendments up here, okay? And I want you to, I know if we were in class together, we would do this, and I'd say, okay, take out a piece of paper and pencil and write down. But we're not in class together, but you can still test yourself. So go ahead and pause the lecture and then just get out a piece of paper and pencil and just see if you can tell me, well, what are the actual liberties that are included in the First Amendment or in the Fourth Amendment or in the Eighth Amendment? Okay, go ahead and pause it, and we'll come back together in a second. Okay, so how did you do? Well, there are 5 liberties that are included in the First Amendment: religion, speech, press, assembly, and the right to petition. And we're going to be spending a lot of time in class on the First Amendment. Second Amendment, the right to bear arms. We'll be spending some time on that. The Third Amendment, as you're going to find, is one of the amendments that has not been incorporated to the states, and you'll learn what that means in a few weeks. But that tells us that Congress is prohibited from courting troops in our houses, and is really sort of a byproduct of the revolutionary times when England would do that. Fourth Amendment, search and seizure. The Fifth Amendment contains many liberties, that you have a right to due process. You can't be charged twice for the same crime. That's what double jeopardy is. You can't be forced to testify against yourself. And one of the first cases we're going to be learning about is a case dealing with eminent domain. And that's that if the government takes your property from you, they have to give you fair market value for that. The Sixth Amendment contains many, many rights that we're going to be learning about, and they all have to do with the rights of a criminal trial. So the right to counsel, the right to confront witnesses, the right to a jury trial. We won't be talking about the Seventh Amendment this semester. It has to do with the civil trial rights. The Eighth Amendment deals with punishment and excessive fines. And so the Eighth Amendment, as you're most familiar with, has to do with the death penalty. The Ninth Amendment is one of my favorite amendments, and it basically addresses the concern that the Federalists had that if you write the liberties down, does that mean that other rights are not afforded to you? And the Ninth Amendment basically says that it provides protections of rights that are not specifically enumerated within the Bill of Rights. You're going to see that the Ninth Amendment is initially used to expand the Constitution, the Bill of Rights, to include the right to privacy. And then the 10th Amendment is something that we won't be talking a lot about in class, but we will touch on it. But the 10th Amendment is the amendment that says that any power that isn't given directly to the national government is reserved for the states. And so how did you do? Hope you did well. But that was just sort of a fun exercise to engage in. Okay, in the second half of this lecture, we're going to take a look at the institutions and functions of government and just a little really quick refresher. And so I think, as many of you know, that the American government is made up of three major institutions of government. Ask yourself, can you name what these institutions are? Well, here's a slide to help you with answering that question. And so I think, as most of us know, that you have the United States Constitution, which establishes the institutions of government. It establishes the lawmaking branch, which is known as the legislative branch. In the United States, the legislature, the federal Congress, is comprised of two chambers. One is the House of Representatives, which is based on population. There are a lot more, 435 members of the House of Representatives. And then the Senate, which is a much smaller and more deliberative body. Every state has equal representation in the Senate. And as you know, there are 100 senators right now because we have 50 states. That we have the executive branch, and the executive branch is, so the legislative branch is created by Article 1 of the Constitution. The executive branch is created by Article 2 of the Constitution. It establishes the office of the presidency and enumerates the powers of the presidency. We also have a big federal bureaucracy that helps the executive branch do its job. So while the legislative branch makes laws, the executive branch puts those laws into power. Okay, they execute or implement those laws. And then Article 3, and this is what we're spending the entire semester sort of talking about, is the role and function of the judicial branch. And so the Article 3 establishes the Supreme Court of the United States. It tells us that there will be a Chief Justice and associate justices, as it's implied. And then it also tells us what the powers of the Supreme Court are, which we will get into a lot more in the second chapter of the class. Okay, so what do the courts do in the United States? The Congress makes laws. The executive branch implements or executes those laws. So what does the court do? Well, to put simply, what the court does is it settles disputes. Okay, a lot of disputes will arise over law and over the implementation of law and other matters as well. And so that's what courts do. They basically settle arguments or disagreements between different parties. That one disagreement that arises is whether a person is guilty of violating the law, and that's criminal law. And so the states and the federal government will have laws in the book saying that certain behaviors are prohibited. If a person engages in that prohibited behavior, then the state has an offense, right? That you've offended the state. And so you charge an individual with the crime. And a criminal trial is oftentimes a settling of dispute between the claim that the state is making that you actually engaged in that prohibited behavior. Another dispute the courts settle is the dispute over if somebody is responsible for some sort of harm or damage that they caused by their actions. And that's regarded as not criminal law, but civil law. Civil law is basically the law that governs the behavior between parties. And so examples of civil law would be that contract law. Like when you are renting an apartment to somebody, there's a contract that you sign, and each person or party becomes a party to that contract, and they have to hold up their end of the agreement. Oftentimes contracts are violated. Let's say you fail to pay your rent, or let's say that the landlord fails to plow your sidewalks like they promised to do. Then there's a dispute about who's the responsible party, who broke the contract, and courts help settle those disputes. What we're going to be spending this semester talking about is not criminal law, although a lot of the cases you'll be reading about will have to do with criminal law. And in some of the cases that you're going to be learning about, you'll be learning about civil law as well. But what the Supreme Court does is that it settles disputes over constitutionality of law. And so they answer the question as to whether or not a law is constitutional. They also answer questions about whether or not an action that an executive, somebody who's putting a law into action, such as a police or a prosecutor or a president, whether or not the actions of those who implement the law or are constitutional, or do they violate the Bill of Rights or other provisions within the Constitution. And so, not this class period, but in the next class, in topic 2, you're going to be learning about the main power that the Supreme Court has. And that's the power, it's known as judicial review. And that is the power to, if it finds a law or an action to be unconstitutional, that law or action can be nullified. Okay, in this chapter, you're going to be learning about different types of courts, and we'll be talking about different types of courts throughout the course of this semester. One type of court that you'll be learning about, and we're going to take a look at the graph in your textbook in one moment, is what's known as trial courts, okay? And a trial court is basically the first court to hear a case. And you have trials in both criminal law and in civil law, okay? And a trial court, when you, since it's the first court to hear a case, it's known as the court of original jurisdiction. In other words, it's the only court, it has the power and the authority to hear a case for the very first time. As you learn in your textbook this week, that the Supreme Court is rarely a trial court, right? That the power of the original jurisdiction of the Supreme Court is very limited, and so it rarely hears cases for the first time. In a trial court, that's what we're sort of used to seeing on TV, right? That's when there is a trial, that there's a jury there, evidence is presented, people come and testify, and then a verdict is rendered. If it's criminal, the verdict is guilty beyond a reasonable doubt. In a criminal trial, or I'm sorry, in a civil trial, the verdict is about responsibility. The person is found to be the responsible party, the one that is responsible for the harm or the damage, okay? That's what trial courts do. Another kind of court that you read about this week is what's known as an appellate court. And an appellate court does not hear a case for the first time. It hears the case on appeal. In other words, it sort of reviews what happened at the trial court in the court of original jurisdiction. When a court that hears cases on review, that's known as that they have appellate jurisdiction, right? Because that they don't usually hear the case for the first time. That the Supreme Court of the United States is the vast majority of cases that it hears is on appeal, on review, okay? And so the much of what the Supreme Court does is that it exercises its appellate jurisdiction. As you read in the textbook, that what happens in the appellate court is there's not a trial, there's not a jury, new evidence isn't presented, there's not a verdict that is rendered. But in an appellate court, that basically it's a review of what took place in the lower court, in the trial court. And so appellate courts, they read court records, they read the briefs that are submitted by the two parties that were, trying to settle a dispute in the trial court. They'll read written briefs of the Supreme Court and other appellate courts. Sometimes the Supreme Court always listens to oral arguments and written briefs. And then basically based on the briefs that are submitted, then they review the actions of the lower court, and then they will basically correct any errors. And so rather than actually rendering a verdict, what happens in the appellate court is the decisions of the lower court are either affirmed or reversed. That's the actions that appellate courts take. And then there are Supreme Courts, okay? And the Supreme Courts are the highest courts in the system, and they usually serve and have an appellate function. And so this is the graph from your textbook that shows the way the American court system is designed. On the right hand of the graph are the state courts. And so each state has its own court system. It's not established by the United States Constitution. That power is reserved to the states through the 10th Amendment. And so it's the constitutions and the laws of each state that establish their state court system. And they're all different, although they have some similarities, okay? And then on the left hand, is the federal court system. Okay, and the only court that's mentioned in the Constitution is the United States Supreme Court. It does say that Congress has the power to establish all lower level courts. And so that it's the Congress through judiciary acts, starting with the Judiciary Act of 1789, that establishes the lower level courts. Okay. And so you can see that they're on looking at the left hand side, the U.S. district courts, there are 94 of those. Those are the trial courts, and they generally hear the cases for the first time. We have the U.S. Court of Appeals, which has 12 circuits and a couple of others, as you'll read about there. And they review what happened at the U.S. district courts, at the trial courts. And then the U.S. Supreme Court is the court that gives the last review of a case. Okay. And so you sort of see the same thing happening on the other side. States have their own trial courts. They're called circuit courts in Wisconsin. They hear the cases for the first time. We have courts of appeals in all states. They're an intermediate appellate court, and they review what happened in the trial court. And then states have state Supreme Courts as well. But if the dispute isn't being settled through the state by the state Supreme Court, or if there are disputes within the appellate court system, then as you'll learn in your textbook, that it's the Supreme Court will take up those cases and offer a final review and a final decision about whether or not the decisions of the lower court should be affirmed or reversed. In conclusion, so hopefully this lecture refreshes your memory about the basics of the organization and institutions of government. I really want to encourage you to watch the short box explainer video on the Supreme Court. It does a great job in a very short period of time, sort of bringing to life the information that you're reading in your textbook about how the Supreme Court decides to hear a case. That the process of how the court decides to hear a case, I'm going to discuss that in the topic 1 commentary, so you can read that. And the next lecture for this week is a lecture on legalism. We're going to be learning about the different methods of constitutional interpretation that the Supreme Court justices use and how that helps them decide a case. Okay, thanks for your time. Thanks for listening, and I'll talk to you again soon.